I do a lot of
advice
things
read
now,
into
but
the
to
record.
repeat the same advice would be futile.
Yeah.
Listen, the advice is very clear. And one of the problems we have in dealing with this issue is that nobody in this room is an expert. Nobody in this room is an expert. And the only expertise that has been involved in the drafting of this bill are the very people that it is designed to regulate. The bill is designed to regulate. I said it at the last meeting on this bill, and I'll say it again today. 4 people lost their lives because of poor regulation, lack of oversight, and reckless behaviour. And that's the only way it can be described. Now, in light of the legal advice we have received, it is my view that neither House at this stage has had the technical expertise to inform them as to the right way to go with this bill. And I believe that I should invoke Article 70 or Standing Order 70 today and seek a select committee of this House to be established to bring in the expertise to explain to us. We are, after all, none of us aviators. None of us are experts in this area. The Minister herself is not an expert in this area. And it is unfair to see this continually drag on the way it has dragged on. The way to resolve this problem now is to bring in independent experts. And when I say independent, we have all been approached by IALPA. IALPA is not independent in this case, right? Independent international experts to explain to us that this meets the requirements of EASA. And if that's the case, then let's rock on with the bill. But right now, I want it on the record, I am deeply uncomfortable with this bill, and I've made that point.
Thank you. No, you've made your point.
Chairperson, and just to reiterate the advice from the Attorney General, that he is satisfied that there is no conflict of interest or a breach of trust in relation to engagement on this. And I just want to maybe further clarify the consultation around this bill, if that helps senators. And I'm very conscious of time as well, Chair, that we want to actually get through the issues, discuss the amendments, and I know senators know that I have moved significantly in relation to putting forward government amendments, and I'm very eager to discuss them here today, because I think that will make for a better bill, and I would like the opportunity to do that. But just, if I can say that Section 14 of the Irish Aviation Authority Act 1993 requires the IAA to advise on its own initiative or at the request of the Minister, the Government, the Minister or another Minister of Government, or any other person in relation to any matter to which a function of the IAA relates. The IAA, as I stated here last time, has very extensive and highly regarded technical experience, and they operate as part of an executive framework, but with an obligation to decide on matters within their remit on an independent basis. A different approach is appropriate where it's necessary to have expertise to assess and conduct the functions by the IAA, or in relation to the possible assignment of new functions. And the Department has availed of such expertise on a number of occasions over recent years. This bill has been developed by the Department of Transport with expert input from the IAA and CAR. Additional expertise was contracted to advise on provisions in respect of search and rescue, and the bill was drafted by the Office of the Parliamentary Counsel. Also, I want to just highlight the level of engagement and consultation that has taken place with stakeholders in the development of this bill. Prior to the publication of the bill by my department, they engaged with the Irish Aviation Authority, the Commission for Aviation Regulation, the Competition and Consumer Protection Commission, the DAA, Cork Airport, Aer Lingus, Ryanair, Airports Council International, Chambers Ireland, ICTU, Forsa, IALPA, An Taisce, Dublin City University. In addition, the bill was subject to pre-legislative scrutiny in July 2019 by the then Joint Committee on Transport, Tourism and Sport. Since publication of the bill, I have met with IALPA 4 times. I have met with senators on 3 occasions. A working group was established to progress development of the bill, chaired by the Department and involving the Department, the IAA and CAR. And in respect of the airport charges regulation aspect of the bill, the Department engaged with ICTU and the DAA and held a workshop workshop involving DAA, Aer Lingus, Ryanair, CAR on the policy aspects. The bill was subject to pre-legislative scrutiny by the Joint Committee on Transport and Tourism in July 2019. Prior to publication of the bill, the Department engaged with a number of parties on the text, including Forsa and IALPA. In addition, the Department corresponded with the following in relation to airport charges, and I've just listed them out there previously. And other examples of engagement with state agencies in the development of legislation, which I think would be helpful for senators to hear here. In relation to the legislation around the Central Bank Individual Accountability Framework Bill 2021, the Department engaged extensively with the Central Bank to inform the policy positions adopted to address the principles as approved by Government. Further extensive engagement was undertaken with the Office of the Attorney General to achieve the objective of ensuring that the Central Bank has the powers it needs to regulate effectively while safeguarding the constitutional rights of all concerned. Minister of State at the Department of Justice, Deputy James Brown, speaking in the Seanad on the 9th of November 2021 in respect of the Land and Conveyancing Law Reform Act. The bill sets out a number of new rules for the law on requiring and validating prescriptive easements and profits à prendre. This follows extensive engagement with stakeholders, including the Law Society, the Bar Council, the Property Registration Authority and the Law Reform Commission. Also, Minister of State at the Department of Justice, Deputy James Brown, speaking in the Dáil on the 6th of May 2021 in respect of the Private Security Services Amendment Act. The then Minister for Justice and Equality, Deputy Charlie Flanagan, made a commitment in the Dáil in September 2018 that the law governing the area of persons involved in the execution of court orders that are not licensable by the Private Security Authority would be examined. The Minister established an interdepartmental working group chaired by the Department of Justice, comprising officials from the Court Service and Garda Síochána, the County Registrars Association, Revenue Commissioners, Department of Housing, Local Government and Heritage and the Private Security Council itself. So this is common practice that groups who are directly affected by legislation would be consulted. But I think the real answer to people's questions here today is the response from the Attorney General around the draft of this bill. And I would ask Chair if we could. I would ask Chair if we could move forward to discuss the amendments and to move through
that. Just Senator Craughwell. Yeah, we will do that. Senator Craughwell has a comment to make in fairness to him.
Look, I have a few points that I need to make today. Right. The first point I have to make is the Attorney General is one distinguished lawyer. The advice that was read into the record today was prepared by another distinguished lawyer. I don't believe any lawyer is more qualified than the other, lest a court judges the positions of both of them and makes a decision. So the Attorney General's advice holds no more water for me than the advice that was read into the record by my colleague, the Leader of the House. Now, a couple of points I want to make. First and foremost, the Leader of the House has written to the European Commission on this bill. And while she disagrees with me trying to invoke Standing Order 70, it strikes me that if we can proceed with the bill today and the advice that comes back from Europe is contrary to the advice or the opinion of the Attorney General, where are we then? We can't go back.
Senator Craughwell, we have, you would have to go to CPP. We're here in committee stage by order of the House. Any processes like Article 7 is CPP, it's outside here.
Well, no, let me speak
We're on committee.
And a point of order, could you explain that, because I don't understand that?
Yeah.
What's the import of what Senator Craughwell is suggesting?
Well, if he wanted to invoke Standing Order 70, he would have to go to CPP and go through a process there. And we are now dealing with, but thank you for the question, we are now dealing with committee stage by order of the House.
So we can proceed today, in other words.
So we must proceed with where we are. Thanks, Senator Bottom.
We must proceed or suspend again, and I don't particularly want to do this.
But I order that.
Okay.
But anyway, make your comment. We want to be very fair.
Right. Now, before I go into the comments I have here, the Minister has referred to advice from, as bills have passed through the various houses of the Oireachtas in all sorts of areas, and the people that were consulted, and that's good. I don't have a problem with that. I do have a problem if we go to an agency and ask them to write the legislation to regulate themselves. I do have a problem with that. You spoke about SAR particularly, and the expertise that are available to your department on SAR. I assume we're talking about the same company. Oireachtas is the only advisor you have in SAR. Because if it is, that's a one-man operation for a massive contract and a massive series of issues that need to be overseen. I note that you recently tendered for an expert for the next SAR contract, and that's due in at the end of this month, I think. Anyway, my amendments speak to the importance of consulting with all relevant stakeholders. Yeah, that's where I am now. However, it's very clear that the department is preparing for the bill, have not done this. Certain provisions of the bill, along with sections of the legislation which implement the EASA basic regulations, are based on the Air Accident Investigation Unit 116 report, which drew attention to the lack of technical expertise. It is ironic that legislation which is partially based on a report that drew attention to the lack of technical expertise has not been appropriately reviewed by people with technical expertise. Next point I want to make is the bill has gone through the Dáil. It was first initiated on the 4th of December 2020. The bill was considered before the Select Committee on Transport and Communications. It's currently before us at committee stage. Not once has the House of the Oireachtas obtained independent technical advice on this bill. As parliamentarians, we need to acknowledge that there are certain types of legislation where expertise are needed. Regarding Irish neutrality, there was talk of a citizens' assembly in which a group of civilians would be presiding over whether Ireland should be neutral, militarily non-aligned or aligned with blocs such as NATO. It's reckless to pass legislation. On important matters such as this without consulting experts. On the 29th of June 2022, the Minister for Transport attended the Seanad. It was their understanding that there is no member of staff within the department with such technical expertise. The department will often commission advice in relation to the bill, but on this occasion it didn't do so. Instead, it relied on the technical expertise of the Irish Aviation Authority in preparing this bill, notwithstanding the fact that the bill is intended to regulate that authority themselves. What could possibly be wrong there? The Minister needs to consult with all relevant stakeholders to ensure proper implementation of the EASA regulation. Now, the Minister has said here that she engaged with IALPA, she engaged with the IAA, and she has engaged with us on a number of occasions. And in fairness to the Minister, I think she has engaged, but she hasn't listened, or at least her officials who are advising her have not listened.
That's not fair.
Look, we're where we are a year on, and we're getting nowhere.
A huge latitude here. Could you just wrap and then we'll put the question?
I think we're at committee stage, Chair, and I think
know
I'm
that,
entitled
but
to make my points.
we're wandering off and back and forward to the amendment.
No, but I think I'm entitled to make the points
We'll
I want to make today. Right? If we're going to proceed with the bill today, which I think is ill-advised, then I'm going to make my points. So, Article 2.6 of the EASA basic regulation allows the Minister to opt into certain provisions and activities and organisations. This is relevant, but with regards to Section 67 and 76, we need to give consideration as to whether they reflect the state of the art and best practices in the field of aviation. This is what I'm talking about when I'm talking about a select committee of the Seanad having experts available to them. I am not an expert. I'm not an expert in the area, so I am being asked, and I will put my name to this bill by virtue of the fact that I've been involved in its discussion. This will be Minister Naughton's bill when it goes into into legislation properly. And the bottom line on it is none of us none of us are expert enough to actually make judgments on some of the things in this bill. Section 67 makes reference to the Minister. It makes reference to conducting a regulatory review along with a universal safety oversight audit programme of the International Civil Aviation Organisation, or ICAO. The bill does not explicitly state what kind of experts the people conducting the review will be required to have. What sort of expertise will they be required to have? Other amendments I have tabled today allow for the appointment of a chief executive who I believe could address this issue. Does Section 67 reflect the best practice in aviation? I don't believe it does, and we need to be incorporating all the relevant stakeholders to ensure that it does. How might this bill not be the best implementation of EASA regulation problems with Section 76? Apart from Section 67, Section 76 invests too much power in the Minister. I believe this would be contrary to Article 8 of the EASA regulation. Under this section, the Minister has responsibility for strengthening the National Aviation Safety Regulation framework. Yes, I know. I'm just trying to bring it all together now. These are the only areas that cause me difficulty. And if we can iron those out, I think we can move on with this bill. The safety regulation framework for the Irish Coast Guard. One of the biggest issues with this bill is the lack of accountability for the Chief Executive. Legislation such as this is too important to allow for incompetence. The pilots programme, the introduction of the pilot support programme is a welcome development. Members of the opposition will have been happy to support this part of the bill. However, a lot more needs to be considered. Right? The Irish Aviation Authority, exclusively relying on technical expertise from the Irish Aviation Authority, is likely to bring compliance with regard to EASA regulations. There needs to be an independent review done by an internationally renowned expert who are independent of the IAA. You're mad for me to sit down, Cathaoirleach.
Very clearly and very lucidly, so there's no need to repeat.
The Shannon should inquire whether insofar as the bill amounts to a measure under EASA basic regulations. In that context, the role of senators, we can request the technical advice be sought under standing order. And then going back to that issue again, I believe that we should not proceed without expert advice. I have some concluding remarks, but you're so anxious for me to sit down, Cathaoirleach. I'll sit down and draw my breath for a few minutes.
To the
Go
amendments.
ahead.
I haven't spoken to the amendments, and I think that it will clarify. The requirement in Irish law for crew peer support derives from EU Regulation 2018-1042. The regulation was developed in consultation with all stakeholders, including pilot representative bodies across Europe. The final regulation represents a consensual balance of the views of all stakeholders. The regulation came into effect in February last year, and the European Union Aviation Safety Agency is required to review its effectiveness later this year. Under the regulation, each airline must enable, facilitate and ensure access to a proactive and non-punitive peer support programme that will assist and support flight crew in recognising, coping with and overcoming any problem which may negatively affect their ability to safely exercise the privileges of their licence. It's up to each airline as to how it implements this requirement, whether it does so by itself, with another airline or indeed with other parties such as trade unions. The key point is that the obligation rests on the airline to ensure its flight crew have access to a crew peer support programme that is in accordance with the regulation. The IAA is the competent authority in Ireland in respect of the regulation. All Irish airlines have a peer support programme in place, and the IAA has audited all peer support programmes as per the EASA requirements. Both Aer Lingus and Ryanair established peer support mechanisms years in advance of the legal requirement, indicating a voluntary commitment on the part of airlines to the principle and practice of crew peer support. Amendment 3 and Senator Doherty's Amendment D4A propose additional national requirements over and above the EU regulation. The amendments propose that the IAA would be required to review airlines' peer support programmes every 3 years to convene a national forum whose functions would include creating or encouraging the provision of a national crew peer support programme. In response, Government Amendment C4A is proposed, which will require the IAA to undertake a review of the effectiveness of crew peer support programmes and in so doing take account of many of the criteria as originally proposed by senators, including addressing matters such as the promotion of use of a programme and trust in it, independence of peers from management or supervisory functions, and selection of training of peers. The Government Amendment does not provide for a national forum, as IALPA have requested. Following extensive engagement with IALPA, it's not yet clear how the objective of such a forum, the creation or encouragement of the provision of a national programme which would be accessible by aircrew from any airline, how it would be operationalised, funded, how it would be structured, what parties would be involved, or the extent to which such a concept would be supported by airlines. I believe that the proposed Aviation Stakeholders Forum is a mechanism by which any safety-relevant issues can be brought forward for attention and teased out in a consultative and a collaborative manner, including issues relating to crew peer support programmes. If the Aviation Stakeholders Forum brings forward proposals to establish a crew peer support national forum, I have committed to legislate for that. As regards the proposal for rolling 3-year reviews, I would make the following points. Crew peer support programmes, whilst important, are only one element of the vast body of systems, rules and procedures designed to ensure safety in aviation. Hard-coding the IAA's efforts and conducting reviews every 3 years is potentially disproportionate and may unnecessarily divert the IAA's resources. If there is a review and there is a need for a review subsequent to the IAA's initial review 12 months after the commencement of this bill, then this can be pressed with the IAA at the Aviation Stakeholders Forum. In respect of the position that a pilot should be able to seek assistance from a peer not working in the same organisation, the EASA regulation places the responsibility on airlines to ensure that they have effective crew peer support arrangements in place. A critical element in the process is for the airline to be guided by a peer as to when a pilot needs to be rostered off and supported. The airline has to be satisfied that the guidance is coming from a source that they are satisfied with and have confidence in. And what is being envisaged in this amendment is a very different model to what pertains now. It's unclear how it would be operationalised, what would be the consequences, for example, from a legal liability perspective. The proposal requires very careful consideration, input from the first IAA review and discussion at the Aviation Stakeholders Forum, and as such I cannot accept Amendment 3 or Amendment D4A. Thank you.
Thank you, Minister. So the Minister has responded specifically to the amendment now. So, Senator Doherty.
Minister, able to respond to the question that I asked before she made her intervention, Chair? Why there was a different approach taken with some set of regulations, new regulations for the IAA versus other regulations for the IAA?
On the specific crew peer support amendment before us today, I don't see any, there is no conflict within my department seeking the input of the IAA. Given the undoubted and extensive aviation safety expertise of the IAA and its remit to promote aviation safety, it would have been remiss of my department not to have sought IAA's input. And in relation to search and rescue, as I have stated, that the department engaged with Aero Assurance in relation to that.
Yeah. It is rather odd that in the area of SAR, an expert was brought in, if you can call a non-pilot one-man operation an expert, to advise on this bill. I'm on record in this House and at committee and indeed to your own department as to the reservations I have over a one-man band providing any advice to the department. And the letter that I got from the department to assure me that that one-man band was providing advice to organisations all over the place. To have a balance sheet without creditors or debtors at any stage in the 3 years prior to getting the contract, it shocks me. And indeed, the tender that you put out recently, your department put out recently for somebody to assist with the procurement of the next SAR contract, you set the turnover of the organisation so low, I think anybody could apply. So I have difficulty with that. But getting back to what Senator Sherlock said, there's very little dividing us at this point in time. A peer support group made up through the pilots themselves, you can have confidence in, because Senator Doherty is correct, Senator Sherlock is correct, Senator Buttimer is correct. Pilots are a very unusual breed of people. They're very protective of their licence. They communicate amongst themselves, but would be slow to communicate in a forum where other people were involved. Do remember, and all of us in this room will probably get on a plane in the next month or two to go somewhere. When those two men walk into the front of that aircraft and close the door, or should I say two men, our women, get into the front of the aircraft and close the door, what goes on in there until that plane lands, none of us will ever know. Frequently, when you're flying somewhere, you see a member of the cabin crew replacing a pilot while a pilot pops out to the loo or whatever. I want, just like my colleagues have said here, I want to know when I get on an aircraft that if a pilot had a problem that day, he or she did not have to bring that problem into the cockpit with them. Every one of us leave our houses every day with a plethora of different baggage that we carry with us for the day. Some days it's good, some days it's bad, some days we're carrying problems that we can't resolve. None of us are 35,000 feet up carrying those problems with us, so we're not. So there's very, very little dividing us at this stage. And when the pilots themselves are saying if they got this amendment, they would be willing and able to participate in every way, I don't accept the fact that it's too onerous on the IAA. The IAA were able to find enough time to come around and meet all of us to try and convince us that this was the way to go. The IAA were found to be culpable in Rescue 116 insofar as they were lacking in oversight. Your own department was found to be an unintelligent consumer of aviation without expertise in the area. And as Senator Doherty said earlier on today, we're 5 years out. 5 years out, and you still do not have an aviation expert on your staff. The Irish Coast Guard still does not have an aviation expert on their staff. What is going on? You know, I fully appreciate you engaging with the IAA on everything, and I respect their right to contact you on any matter they feel fit to advise you on or to comment on. I have no difficulty whatsoever with the IAA doing that. I do have difficulty with them being the main influencer in this bill. I do have difficulty with you not accepting that at least once every 3 years this would be reviewed. It's not an onerous task. It's not going to consume them totally. And if somebody needs to be employed to carry out that work over a 3-year period, then employ them. God knows you read out a list of experts here the last day you were here, and there's enough of them out there, so there is. This bill needs to pass. And what has been holding us up is this and the pilots forum. That's what's holding us up. And let's be honest about it, Minister. As a minister, if you had difficulties in your department, you'd feel comfortable talking to another minister. You wouldn't come in here and talk to us about it. We wouldn't sit down in the dining room and have a chat about the difficulty of dealing with people or whatever. You deal at your peer level, and you're happy to do that. And that's all that we're looking for here. And I think if we can move to that stage, we can probably move on with this bill. Failing that, I am really concerned that advice will come back from Europe that we have gone the wrong direction. And if it does, then where are we? You know, I still have the view we shouldn't proceed with this today, but there we go.
Thank you for cooperating by a couple of speakers. No, well, no, but you've done it proper. I'm not
but just on a
impugning
point of
you.
information, It is not the chair who decides when the question is put. It is the members who decide.
Okay, but it's in the good interest of the management of the House. Minister. We're all on the one team in this regard.
Thank you, Chair. Just in relation to the existing peer support, we have the same law as the rest of Europe for crew peer support, and that is enforced by the IAA. And also, I suppose your initial question, Senator Doherty, around the engagement of the IAA and why. I suppose, number one, the crew peer support programme is already covered by EASA regulations, and as I've stated earlier, there's no conflict engaging with the IAA in relation to this. Senator Sherlock, just again in relation to your call for the national peer support programme to be put into legislation.
No, I understand. But I suppose it's the detail within the peer support as set out in the amendments here, like the gap is small.
And that's precisely, I suppose, the issue when I have been engaging with IALPA and ask how it's going to be funded, how it's going to be how it's going to work, how it's going to be structured. Those answers aren't there, and that's fine. But it's through the Aviation Stakeholders Forum where, and we're talking about trust and confidence in what is a really important, potentially national peer support programme. That's where you need that collaboration and to be able to put forward a proposal that I am saying that I am willing to legislate for, but it needs to be done through that stakeholders forum because it needs to have the trust and the confidence of airlines, pilots, all of those key stakeholders who will be using this potential national peer support programme. Also, in relation to the review, like the government amendment requires the IAA to, within 12 months, to review the peer support programme. And that in itself, that review, will feed into the work of the stakeholders forum when they're formulating what could potentially be a national peer support programme. And that's what we want, the best policy, the best legislation, one that has the confidence of all stakeholders in relation to protecting those who need that peer support. And that's why and again, my door is open here in relation to crew peer support. I want exactly what you all want here, to ensure that people have confidence in it, it's workable, we know how it's structured, how it will operate, how it's funded, all of these issues. And that is a commitment I've given here over and over again, but it needs to be worked out through the stakeholders forum. Thank you.
Thank you.
So if you can press it, I would be
right.
really obliged.
Did you say you had a question or something?
Look, I accept the Minister's bona fides on this, but the stakeholders forum will include people other than pilots. And what we're arguing here is that pilots need to have their own forum.
Okay, that's very clear. So, Senator Craughwell, do you want to firstly move the amendment?
Yes, Chair.
And you wish to speak to it?
Very briefly, Chair.
Committee stage, it doesn't need a second or so.
What we're doing there is adding in that the report there will also come to the plan submitted to the Minister should also be submitted to the houses of the Oireachtas, and in that way their Oireachtas committees, etc., can get involved in the plan that's put forward. So I'm not going to delay any further on this other than to ask the Minister to consider adding in the words there and the houses of the Oireachtas.
Thank you. Thank you very much indeed, Senator Craughwell. Does the Minister want to respond to Senator Craughwell, please?
Thank you. This is okay, so Amendment C, 3C, 3G and 3H.
Yes,
thank you.
Yeah, thank you.
The business plan of any organisation is an internally focused executive document. It is in effect an operational plan for a given period. It may contain commercially and operationally sensitive information. As such, it would not be appropriate to place it in the public domain. The IAA will be subject to a range of accountability mechanisms provided for in the bill and existing legislation. Such accountability mechanisms include the laying of the Statement of Strategy and the annual report and financial statements before the houses of the Oireachtas, and the requirement under Section 77 of the bill that the Chief Executive or relevant officer shall account for the performance of the company's functions to a committee of one or both houses of the Oireachtas. As such, I cannot accept Amendment 3C. Section 67 of the bill provides that the IAA will submit to the Minister an annual report on its performance in regulating aviation safety. It sets out that the report will include planned activity for the coming year and a review of the past year's activity. Section 67 requires that the Minister must, within 1 month after receiving an aviation safety performance statement from the IAA, lay it before each House of the Oireachtas. Amendment 3G and 3H in effect require that the report be submitted to the Minister and the Houses of the Oireachtas simultaneously. Given the requirement for the Minister to lay the report before the Houses within 1 month of receipt, these amendments result in an unnecessary bypassing of the normal process of a Minister seeking briefings and clarifications from the state body for which they hold policy and corporate governance responsibility before the report enters the public domain, and as such I cannot accept amendments G and H. Thank you.
Just a comment from Senator Craughwell is it back, and then we have Senator Craughwell.
The first thing on the issue of commercially sensitive detail being contained in reports. This has been used constantly now at both committees and within houses of the Oireachtas. The commercial sensitivity is about other commercial entities. The House of the Oireachtas, and this is a problem probably for the House of the Oireachtas and for the committees in the Oireachtas as much as it is for the Minister, we should be able to have access to information. Far too often we're being cited commercial sensitivity, commercial issues with respect to denial of access to information. It is very, very clear in European regulations that the function of the Houses of the Oireachtas is oversight. And it is up to the Houses of the Oireachtas to have oversight. In a recent communication from your own department, they cite European Regulation 24 of 2014, Section 18.1. And in that, they talk about, your department talks about not being unable to hand over certain information or being unable to appear before an Oireachtas committee because of commercial sensitivity. If the author of that letter continued to read on in the European directive, at Article 83 of the same directive, he or she would have seen that they are obliged to be overseen by the Parliament. And that includes parliamentary committees, it includes special committees put together for oversight purposes. Far too often, the function of either House of the Oireachtas or the committees within the Oireachtas is being diluted through this excuse of commercial sensitivity. I have no difficulty with the second part there where you spoke about Section 67 with respect to the Minister getting the report first. However, I will say, Minister, and your own department again is responsible for this, you've had reports into maritime issues that we're still waiting to have released. Almost a year out, if I'm not mistaken, maybe longer than a year. So, even though it says in the legislation that it has to be released within a month, is there a likelihood at some stage in the future that a minister will say, for commercial reasons or for whatever reason, we are unable to publish the report? This is why we're trying to hardwire this into the legislation, that it has to come before the Houses of the Oireachtas. So I'm a little, I accept your bona fides, Minister. I accept that you would want to publish something within a month, as it states, but it may just be possible that your officials would tell you you can't. And where do we stand then? We, after all, are supposed to be overseeing the departments. It's not the other way around. And we need to make that. Yeah, your colleague in Fine Gael, Michael Ring, made a very, very strong speech about the need for Oireachtas members to be able to oversee things, and that's something that we really need to dig our heels in on and make sure that we are treated with the respect that those who elect us require of us.
Thank you very much.
Just in relation to Senator Craughwell, it's hardwired into this legislation that the Minister must lay Section 67, the 67 report before the Houses of the Oireachtas within 1 month. It is in the legislation to do that. In relation to Senator Doherty around what could be in the business plan, so just first of all to say that the IAA will be subject to a range of accountability mechanisms provided for in the bill. Like, for example, a business plan, it's a document that defines in detail a company's objectives and how it plans to achieve its goals. It lays out a written roadmap for a company from financial and operational standpoints. As such, a business plan can contain information on financial positions and intended expenditure, operational readiness and business risk and response to same. Should the business plans be in the public domain, there's a risk that the contents of the plan alert regulated entities to specific work that the regulator will be carrying out in that period. For example, if the business plan included information on procurement expenditure for certain projects, this could alert industry to a body of work the regulator intends to carry out, give an advance notice, if you will, to those regulated entities. And while it's correct that through the publication of the Statement of Strategy, the public is aware of a strategic level of the work that will be carried out, publication of internally focused business plans does carry risks which could ultimately fetter the work of the regulator.
Final comment before I put the question.
It mightn't be the final one, but it's a comment. I don't understand why it would alerting the organisations that in the business plan they're about to do A, B or C, or they're about to purchase A, B and C in order that they can carry out their function. Surely there's nothing wrong with people knowing they're going to be inspected. Surely there's nothing wrong with the regulator pre-advising people. It doesn't stop the regulator from carrying out snap inspections if that's what they want to do. But I mean, to think that we would be unwilling or afraid to inform or advise those that are to be overseen by the IAA, that the IAA is moving in a particular direction, I just don't see how that's a bad idea. If it was the commercial side, that would be a different thing. This is not the commercial side, it's the regulatory side. And I just don't see a problem in knowing in advance. I mean, if I take an example from my previous career, whole school inspections, you're notified in advance that there's one coming, so as you can prepare for it and make sure all the I's are dotted and T's are crossed. And by introducing that system, we have improved schools all over the country, so we have. What would be wrong with people knowing that they were about to be inspected by the IAA, or that the IAA was bringing in expertise, or that the IAA was bringing in specific equipment or whatever? I can't accept that at all.
It doesn't seem as if we're going to get a meeting of an agreement on this. There's no change. So the question is Amendment 3C agreed? Agreed? Thank you.
No.
No, not agreed. Okay. So the question is that the amendment be made. Those in favour say "thaw." Those against?
Yeah.
Sorry. Yeah, the other way. Sorry. Those in favour say "thaw." Thaw. Those against? Yeah. The question is defeated. Sorry. Yeah.
Inishan Kesht. Air Navigation and Transport Bill 2020 Committee Stage Amendment 3C in the name of Senator Gerard Craughwell. The question is that the amendment be made, and on that question a division has been challenged. Tellers Thaw, Senator Gerard Craughwell and Senator Lynn Boylan, and Neil, Senator Sean Coyne and Senator Robbie Gallagher. The division will be conducted electronically. The voting time is 1 minute, starting Inish.